Right, I think we've got quite a lot of people in from the numbers are expected from the sign-up sheet, so that's great. Good morning, everybody. Very warm welcome to the next instalment in the King's Chamber's commercial series of these morning seminars. Really lovely to have a great turnout, really lovely to have you all here. Thank you very much for supporting us. So this morning, what I'd like to talk to you about is abuse of process and the rule in Henderson and Henderson. Move on to our first slide. So the very broad area of law that we're talking about here within civil procedure is the situations within which it is okay to have repeat litigation, repeat arguments about the same sort of subject matter. If your multi-gazillion dollar Death Star gets blown up the first time, can you have another go and build another one? I make no apologies for all the repeated Star Wars references you're going to find in this talk, but bear with me, it is an overcast Tuesday morning, and I'm talking to everybody about the civil procedure rules, so I had to do something or other. Keep your eyes open for whatever references you can find in the talk. Just to put the rule in Henderson and Henderson into some context for you, I've taken this diagram from a description in the Virgin Atlantic Airways case from Lord Sumption. You can see the citation at the bottom left of the slide. We're dealing with the very broad area of res judicata, which is a series of doctrines about things that have already been decided and therefore shouldn't be decided again. And it breaks down into a number of sub-points. And I've just put this diagram out here to give you a bit of context so that you can see where the Henderson and Henderson rule fits into other things, how it interrelates to other similar doctrines. What you've got is cause of action estoppel, res judicata in the narrow sense of the word. So sometimes people will use the term res judicata to mean this whole broad area of concepts. Sometimes they'll use it to mean specifically cause of action estoppel. That's where you've had the same exact cause of action dealt with in earlier proceedings. You've got issue estoppel, where it's not necessarily the same cause of action's been decided previously, but the same issue has come up and it was a necessary issue to be dealt with in the earlier proceedings. I've put another couple of doctrines just with a little dashed line there, merger doctrine and conquer and boot. Not enough time to go into those this morning, but just so that you're aware of them and that where they fit into all this. What we're talking about this morning is the Henderson and Henderson rule. And what distinguishes that from the other two, the cause of action and issue estoppel, is that Henderson is not about things that have already been decided in a previous case or proceedings or whatever. It's about things that arguably could and should have been decided, but weren't. So it's a sort of negative doctrine. It's an argument that somebody's bringing something up for the first time, but they should have brought it up earlier. And that's what makes it quite an interesting and flexible doctrine, as we'll come on to. Now, the original leading case on this is the case of Henderson and Henderson, unsurprisingly. It's from 1843. And before we go through some of the more modern refinements, what I'm going to get on to tell you in a couple of slides' time is that this case isn't really good law anymore, and you're unlikely to want to rely on it in proceedings. But it's worth just having a look at the way this rule was originally formulated. So I've put the key extract from the original decision up. I'm not going to take you through the facts of it because it's a really fiendishly complex case. If you try and read it, it's a cross-border probate and trusts and partnership dispute between England and Wales and Canada, and it's all full of 19th century terminology. It's not a sort of case that's very user-friendly to cite in court, and luckily we don't need to. But we've just got this extract here, which tells you how the court saw the rule when it was first formulated. Where a given matter becomes the subject of litigation in and of adjudication by a court of competent jurisdiction, the court requires the parties to that litigation to bring forward their whole case and will not, except under special circumstances, permit the same parties to open the same subject of litigation in respect of matter which might have been brought forward as part of the subject in contest, but which was not brought forward only because they have from negligence, inadvertence, or even accident omitted part of their case. Now, it's worth unpacking this a little bit. I've put some of it in yellow highlights so you can see some key words here. The first thing to look at is subject of litigation and adjudication. So this whole area of argument, Henderson and Henderson doctrine, requires there to have been some previous litigation or adjudication of some kind. What that precisely is, we'll come on to later. But if there effectively hasn't been some form of court decision or process beforehand, you can't raise it the second time round. The second thing I've highlighted here is that this is a doctrine about bringing forward your whole case, and the court is looking at things which might have been brought forward previously but weren't. So this is this kind of negative doctrine that I've mentioned earlier. That's what distinguishes it from the other things in this general res judicata kind of area of law. So it's an older authority, sir, but it checks out. I was about to cite it. The point is, Henderson and Henderson is something you would want to cite potentially, but it's not the up-to-date formulation of the law, and there's only so far you can use it. You need to use it with caution, because what has happened since then is that it's been fairly comprehensively reformulated by the courts in these two decisions. And these two cases, Johnson and Gorwood and Dexter and Bleeland Body, are the two that you're likely to want to use as your starting point if you're writing a skeleton argument or a letter or whatever it is that's arguing about the Henderson doctrine. You can pretty much scrap everything that comes before these two and start from this as your starting point for the rule. So before we go into the two of them in a little detail, I'll just explain what they're both good for. Johnson and Gorwood is the leading recent authority. I say recent, it's 2002, but it's the leading authority as things have been reformulated. And what it does is it reworks the rule, and it introduces what the court describes as a broad merits-based approach. So we're no longer talking about an inflexible rule that says if you do this, that, and the other, you can't bring your second claim. We're talking about a much wider, holistic doctrine where the court is looking at all of the circumstances. What then happens very shortly afterwards is that in Dexter and Bleeland Body, the Court of Appeal really helpfully summarizes Johnson and Gorwood. So the way that the doctrine is reformulated in the Johnson case, if you look at it, it's a sort of long paragraph of prose describing how this works. And then the Court of Appeal in Dexter, particularly Lord Justice Clark, goes and breaks it down into 6 bullet points. So it's that extract of paragraph 49 of Dexter that you're most likely to want to use as a sort of user-friendly summary of what the modern law on this is. If I'm doing a skeleton argument, I'd be quoting that passage from 49 of Dexter, either in full or extracting the bullet points that are relevant to the case. So these two are your starting point, and this is going to help you a lot more than the original decision. What the two of them between them have meant is that it is quite a lot harder to establish Henderson and Henderson abuse. And I've just quoted the last 3 of the 6 bullet points that you get in Dexter at paragraph 49. So what Lord Justice Clark says is, it is wrong to hold that because a matter could have been raised in earlier proceedings, it should have been, so as to render the raising of it in later proceedings necessarily abusive. What the court is saying there is there is a difference between could have been raised and should have been raised. They're not the same thing. So prior to this case law, you'd have had a much more simplistic approach where you would say this is a matter that could have been raised earlier, it hasn't been. Now, that is only step 1. That gets you to the beginning of the inquiry, but you need to go quite a bit further than that. And it's these final 2 bullet points, 5 and 6, that make it significantly harder to make a Henderson argument stick. You've got the broad merits-based approach, and this last one I really highlight to you. The court will rarely find that the later action is an abusive process unless the later action involves unjust harassment or oppression. So this is setting quite a high bar. We're no longer looking at, could you have brought it earlier, did you? We're looking at, by splitting your argument up and bringing it sequentially, is it a harassment, is it unjust, is it oppressive? And that's obviously takes some doing to persuade a judge of. One interesting area in which the sort of woolliness or vagueness of the Henderson doctrine can actually be quite useful, and it's always nice to find a situation where you turn things on their head, but a situation where it can be quite useful is if you're ever representing somebody in a case where you just want to show that there's a good arguable case of some kind. So, for example, setting aside a default judgment where you say we've got at least part of our defense is Henderson and Henderson abuse. If the facts will support it, you can go to a judge and say, well, it's a doctrine that requires the court to look at all the circumstances and reach a holistic decision. So there's got to be a reasonable case. Can we please get through? Or, for example, with a statutory demand, setting aside a statutory demand, there's a case that myself and Nick Taylor from King's Chambers were both involved in, which I'll come to a little bit later on the slide, where we used precisely that sort of argument, unsuccessfully, unfortunately. But yes, it does have an interesting bearing in those cases where the test is a little more nebulous, but where you're actually trying to make out the abuse definitively, it's not so easy to do following these authorities. And just to give you an illustration of that, as one cannot comprehensively list all possible forms of abuse, so one cannot formulate any hard and fast rule to determine whether, on given facts, abuse is to be found or not. And then the Obi-Wan Kenobi version at the bottom, just saying pretty much the same thing. So it's worth having a little bit of a look at, before I move on to some of the case law since Johnson and Dexter, it's worth just having a look at the facts of those two cases to give you an illustration of the way the court does this balancing exercise of looking at all the circumstances and looking to see whether conduct is an abuse when you look at it in the round. Johnson and Goldwood is a case where we have different claimants, same defendant. So at the top of it, if you see the three boxes at the top, I've set out in a very, very simplified nutshell, I've set out how the original dispute arises. You've got the company Westway, which instructs Goldwood solicitors who fail to exercise an option correctly over some property as against a third party. And what then happens is that Westway have to get involved in some costly litigation to vindicate their rights and put right the issues with this option that's not been exercised according to its terms, allegedly. And in the first claim, you then get Westway, the company that's instructed these solicitors, bringing professional negligence proceedings and settling them. And then the second claim is the director of Westway, who brings a further claim for some personal losses against the solicitors. And the court decides that that isn't a Henderson abuse. There's one element of it that is struck out on the basis that it breaches the reflective loss rule, which is out with this talk, really. But there's an element of it that on conventional company law principles can't be pursued a second time round by the company director personally. But the claim as a whole is not abusive in that case. And the court goes through this exercise of looking at all the different factors and deciding whether conduct is abusive and so on. One of the things that is important is that the original settlement agreement in the earlier claim seems to actually contemplate that there is a possibility of another claim being brought. So it seems to be something that's been floated between the parties earlier on, making it less likely to be abuse or harassment to bring that second claim. And the fact that the parties are different is an important factor as well. So that's an illustration. The second illustration, Dexter and Bleeland Body, this is a really fascinating case on its facts. It's actually a case involving a very sophisticated-looking scam against a bank. I say scam. The case is decided on assumed facts rather than proven facts. So I don't think it was ever conclusively established. But essentially, this company, Dexter, borrows £2 million, which is supposed to be to buy an aircraft engine, and they're a company in the industry. But what it actually is this very elaborate fraud in which the aircraft engine does exist, but it's a sort of useless piece of scrap. There's forged documents, there's forged paperwork. And what it's really about is getting the bank to lend £2 million that can then be effectively made off with. So it gets dissipated to company officers and family members, and the mother takes some of it, and whether she actually knows about it is another question. Where it all goes wrong is that the company itself ends up in administrative receivership, and it then starts chasing up the lost money. So it brings a claim against a company officer first of all, and then it brings a later claim, which I think is against the mum, who's the family member who's had to have money out of this. And what the court says in that case is that it isn't an abusive process, because whilst you could have put all of your defendants together in the earlier proceedings, in this case, there is an obvious defendant and there's a less obvious defendant. There's the closely connected company director and there's the less closely connected family member. And you are entitled, in the circumstances, to go after the obvious defendant, leave the less obvious defendant to later proceedings if you need them. So that's another example. The two cases we've just looked at, Johnson and Dexter, are actually mirror images of each other, because one of them is different claimant, same defendant, and the second one is same claimant, different defendants. But this is a sort of balancing exercise that the court will look at and going through everything. So we come on to our third big case, and this is the Aldi Stores and WSP Group case. The reason I bring this one up, in terms of its facts, it doesn't really take things very much further. It's an illustration of the same principles we've already been talking about. But there is some really important guidance in it at paragraphs 30 and 31 about case management. And these really need to be borne in mind. If you go away with, leaving aside the original Henderson and Henderson decision, if you go away with any authorities from this case that are important as your starting point, it's the two that we've just looked at and Aldi Stores. Between the three of them, you'll get pretty much all of the principles you'll need, at least as a starting point, before you work on any kind of refinements of it. So Aldi Stores is a case where there's sequential claims against different defendants in a kind of order of priority. So Aldi have leased a newly constructed store, and because of a technical issue involving the compaction works to the ground, the whole site suffers from this sort of differential settlement, so the building has got fundamental flaw with it. What Aldi do is they bring a claim against the main contractor first of all, and they leave all of the other possible defendants off. So there are a couple of other contractors, WSP is one, Aspenwall is another, and they're involved in Aldi's claim only as Part 20 defendants. They've been brought in by the other parties. So Aldi never brings a direct claim against them. It just goes ahead with his claim against the main contractor. And it's only when Aldi fails to get the full judgment sum off its main contractor that it decides to start taking action against other potential defendants. I think Aldi, they don't get the judgment enforced in full because their original defendant is insolvent. It does have insurance, but the insurance doesn't cover the full amount of the judgment debt. So it's only when Aldi has exhausted its remedies and its practical recovery that it starts chasing up other potential defendants. Those defendants, unsurprisingly, say, well, this claim is an abuse, and you could and should have brought your claim against us in the earlier proceedings. We were Part 20 defendants. We were in front of the court. We were being cross-examined about all the same stuff. Why didn't you sue us then? The court says, in the situation, it is not an abusive process. The claim is allowed to go through. But what the court does do is it gives some guidance about case management. And it specifically says case management in complex commercial multi-party litigation. But potentially it's something you want to be aware of in any case where Henderson is abused, Henderson abuse is raised. So what the court says in Aldi Stores is that if you are bringing a claim but reserving the right to bring another claim separately, sequentially, something like that, you should let the court in claim one know about it so that the court can decide how to case manage it. And it makes sense as a claimant. You want to give yourself the best possible protection against this sort of argument. So if you say to the court early on, we are suing defendant one, we are reserving the right to pursue defendant two, defendant three if we need to later on, at least you've laid down a marker. But more importantly, the court says you've got to. This is compulsory. There can be, it says, no excuse for failure to do so in the future. Now, I know I said it relates to complex commercial multi-party litigation, but I think, and I've had this in some cases I've been advising on, where you're potentially bringing a claim against one party and you've got another party that you might be saving up, or another claim that you might be saving up as a secondary one, it's always actually a good idea, unless you really need the element of surprise for some reason. And I don't quite know that would fit into the CPR scheme of being upfront about things. But unless there's some very good reason not to, it's actually quite helpful to put that into your correspondence early doors, even if it's not a sort of complex multi-party construction dispute like Aldi stores, because it lays down a marker, it gives you some protection, it gives you something you could point out when you're in front of a court the second time round defending a Henderson-type argument. And also from a defendant point of view, it's quite a useful thing if you find that the opposing party hasn't done it, because you've got this quite clear statement that this is absolutely compulsory, you need to follow this guidance, and if you don't do it, then you're in trouble. But, and that there's always a but, we have to ask the question, is this guidance without teeth? Because there's a more recent case, Crete Capital, in which the court decided that non-compliance with the Aldi store's guidance on case management does not result in a mandatory strikeout. The court is entitled to gauge the seriousness of the failure and take it into account as part of its overall assessment. So it would appear that Aldi stores gives you this guidance on how to case manage situations. It is compulsory. The court will absolutely deprecate you not doing it. But if you don't do it, you can still plead your case and say, oh, I'm sorry, I didn't follow this for whatever reason. And the court will have to balance that up with everything else as part of its broad merits-based approach. So it's, on the face of it, guidance that absolutely needs to be complied with. To what extent it's actually going to give defendants a quick win is another question, really. So to recap, we've done the original rule, the 1843 rule. We've looked at Johnson and Dexter, the two modern cases that have reformulated it and summarized it and given us this much wider, broader kind of balancing exercise. We've looked at the Aldi stores guidance, which is this very important guidance on case management if you find yourself in this sort of situation. And I just thought I would go through a list of other factors that are and are not relevant. So we'll start with things that are not relevant. Case law pre-Johnson and Gorwood is not likely to be relevant for the most part. There are some comments in Barnett-Waddington trustees that suggest that you might need to look at it for certain things, but effectively you can start with Johnson and Gorwood, and anything before that is not going to be very helpful. Substantive merits of the claim are not relevant unless it is what's described as a clear-cut case. And to be honest, if it's a clear-cut case, you've probably got a different argument up your sleeve anyway than Henderson and Henderson. And depending on which side you're on, you may have bigger problems to worry about than Henderson and Henderson. But substantive merits don't really come into this sort of balancing exercise that the court has got to do. Delay is another one, and it's a little surprising because you think in a case where we're talking about harassment and oppression, what you very often want to say, if you're on the receiving end of repeat litigation, is you want to go to the court and say, you know, the claimant has brought this claim against me the first time round, and then they've waited till the last possible minute, and then they've come after me with repeat litigation arising from the same thing, you know, day before limitation expired, or whatever it is. That can be quite helpful presentationally. It can be helpful to allow the judge to sort of get a flavour of what's going on. But strictly speaking, legally, it isn't relevant. It isn't a factor. The court will work on the basis that if you are within your limitation period or you aren't barred in equity for delay, then you've got the whole of your limitation period to bring your claim in. So that isn't treated as a factor. What else is not relevant? Exercise of discretion. So in the earlier cases, and certainly in Aldi stores, what the court says is that this exercise that it goes through in the Henderson broad merits-based approach, the court says it is not an exercise of discretion. There is a single right and wrong answer. The court is looking at all the factors and saying, is it or isn't it an abusive process? It's a distinction without a difference, because effectively when the court is weighing up all the factors and making a value judgment in all the circumstances, it's very, very difficult to see how that's different from an exercise of a discretion. It's splitting hairs almost. And in the case of Mawaha and Entertainment One, the court, which was an appeal against a first instance decision on a Henderson argument, the court says, in practice, it's quite a lot like a discretion. From the point of view of overturning it on appeal, it's quite difficult for the court to overturn the decision at first instance when it's this sort of very holistic value judgment. Another thing that is not relevant is the fact that you mentioned a claim in earlier proceedings without actually pursuing it. So the Warburton case is a very recent decision where, to put the facts into a very brief summary here, the claimant is an individual who is suing a police force for disclosing a vetting file on him, which had some allegations which prevented him from getting another job with a different police authority. So he says his career has been kiboshed by unlawful disclosure of some unproven allegations from his past that have come back to haunt him. And he brings a claim on legal basis A, and then tries to bring a claim on legal basis B later on. Legal basis B is to do with breach of the Data Protection Act, which he doesn't bring the first time round. And what he tries to do is get around the Henderson rule by saying, yeah, I did deal with this in the earlier proceedings. I flagged up that there was a claim based on data protection rights in the earlier proceedings. So it's not a case where you can say I should have brought it along in the earlier proceedings, but I didn't, because I did. And the court says, no, actually, to escape Henderson on those grounds, you need to have actually brought the claim. You can't just flag it up or raise it with the court as a background fact without pursuing a remedy for it. Some more things that are not relevant. These things are all things the things on this slide are all to do with the scope of the doctrine. So they're to do with situations where it does or doesn't apply. So the fact that the first claim is dealt with by compromise or settlement does not stop Henderson from biting the second time round. But the original decision talks about an adjudication by a competent court. But actually, if you have a compromise of a claim that is before a competent court, it doesn't get in the way of using the Henderson doctrine. Same thing quite recently in King and King's Solution Group. It is true of discontinuance. So a claim that's resolved by discontinuance, potentially Henderson can still apply the second time round. I find it really fascinating that a rule that is originates in 1843 and has been comprehensively reformulated over 20 years ago into a series of nice, neat bullet points. And in 2020, the courts are still exploring the limits of this doctrine and working out exactly how far it goes. This is a nice illustration of how flexible the common law can be sometimes. What else is not relevant? The fact that the first and second claims are actually interim hearings in the same proceedings. So Henderson can apply to interlocutory decision 1 and interlocutory decision 2. If you try and raise an argument on the second one that you didn't do the first time round, although there can be some quite subtle qualifiers to this. So I've included the case of Wilson and McNamara. I won't go into the facts now because we probably don't really have time for it, but that's the case where that argument didn't succeed because of the way the procedure had been laid out and what did or didn't count as an interim decision. So there's a trap there to watch out for. I've left it on the slides. I should say these slides are available later. So I should really have said that at the beginning so you weren't all taking notes of citations and case law. But the slides will be made available, and it's worth just having a look in a little bit more detail at the Koza case and the Wilson case just to see the subtleties of how it applies to interlocutory proceedings. The Seal Austria case tells us that the second claim can be an amendment to existing proceedings. That's a case that it had quite unusual procedural history where effectively there's a decision on appeal that is made and it's then remitted to the court of first instance to go and decide it again. And then there's an attempt to amend the claim to bring in a brand new claim effectively. And the court says that that's an abuse. You could have done it the first time round. I suspect that's relatively less likely to come up in practice, but it's there in principle if you need it or if you need to try and get over it. And then finally, the repeat litigation can consist of a defence that could have been taken earlier as opposed to a claim. So those are some things that don't knock out the Henderson doctrine. Just some key things that are relevant and that are factors that you'll want to rely on. It's really important to identify early doors, whether we're talking about the same parties and different parties. We've already looked at the Aldi Stores case, the Johnson case, and Dexter, where you have combinations of same claimant, different defendants, and vice versa. That's always going to be a factor. And in a case where the identity of the parties changes from claim 1 to claim 2, you're going to find a more sympathetic court. The middle one is, I think, really important. I think this is something that you really need to think about at an early stage, particularly if you're a claimant. It's what are your grounds for pursuing the litigation separately? The Aldi Stores is a really good example of how to present that to a court, because if you look at it, the court is quite sympathetic to the fact that Aldi have got an original remedy against an obvious defendant. They've got a more remote remedy against some other defendants with whom they're not in a direct contractual relationship, and it's a harder claim to pursue against the other contractors further down the chain. And what the court says is you haven't got to have 20/20 hindsight. At the time, Aldi didn't know that they were going to need their backup claim. They didn't necessarily know that they would need to sue various other defendants. They might have been able to get everything they needed out of defendant 1, and it's a reasonable commercial decision. Could have saved them money. It could have saved court time. It could have saved those defendants from being dragged to court at all if it wasn't necessary to bring a claim against them. So it's only with the benefit of hindsight that you know that Aldi actually did need to bring these other defendants in. At the time they made their decision, the court says it's a reasonable decision because it could have actually involved quite a lot less hassle for everybody. So it's always looking back to what is your rationale at the time that you decide to not pursue everything in the same action, if that's what you decide to do. And then very closely related is the extent to which a party acted reasonably in taking due diligence to establish its case the first time round. So Barnett-Waddington is, just get the facts of it up here. It's quite an interesting case in which, this is really quite complicated, but effectively, the bank tries to rely on one financial instrument to set up its claim for a large amount of interest. There's a big dispute about contractual interpretation, and it turns out that it can't rely on this particular financial instrument. It's an interest rate swap, I think. And then the bank dredges up another financial instrument, which it says it can rely on instead, which it just didn't identify first time round, and it never actually... It, in fact, it did positively claim that there wasn't any such second financial instrument that it could rely upon. So in that case, the court is looking at whether the bank has acted reasonably. It's got 2 limbs to its claim. It's missed off limb 2 completely. And if it had done the right digging and the right sort of looking through its own records, it might very well have found that it had these 2 alternatives, and it didn't do. The reason why Barnett-Waddington is quite helpful is because there's this earlier decision, Stewart and Goldberg-Linda, which I've cited on one of the earlier slides. That case says that you haven't got a duty to take due diligence, that there's no absolute duty on a party to do all its investigations as to what alternative claims it's got. Barnett-Waddington comes along and dilutes that, and it says, well, actually, when the court is doing this broad merits-based analysis and looking at all of the circumstances, you can take into account the conduct. What has the claimant done, or potentially the defendant done, to actually look and see where it stood and get all of the facts out the first time round. So just a couple of final slides for you on cases where Henderson has come up in settlement and compromise situations, which I've entitled Help, I Thought I'd Settled This Claim. So just 2 recent-ish cases that are quite interesting on this point. One of them is Mawaha and Entertainment One, which is a King's Chambers case, and you can see I've put a little mugshot of myself and Nick Taylor. I did this case at first instance, By the time it came around to appeal, I'd gone off on sabbatical, and Nick very kindly picked it up for me. I've got to be a little careful. So everything I'm saying about this case is based on the publicly available judgment. Obviously, wouldn't be discussing anything that's gone on between myself and the client. So I am just commenting on the judgment that you can get online. And this is a case where the claimant is the employer, defendant is a senior employee, and he's alleged to have been engaged in dealings that to his own business's disadvantage. He's getting he's placing trades on claimant's behalf, and it's alleged that he's getting bribes or kickbacks in exchange for doing this. And what the defendant says is that this alleged bribe is actually a loan. There's no dispute that he receives £1.3 million, but he says it's a loan from a third party. And it's legitimate. It's not a bribe or a kickback. What the claimant does, through just some quite convoluted facts that I don't need to take you through all the details, but by happenstance, the claimant is in a position to actually get an assignment of this loan to itself. So the claimant has got effectively a second string to its bow. It's got the original claim for a bribe and so on, and it's got this loan claim, which is quite a lot more straightforward, and it's difficult for the defendant to deny it because that's positively his defense. He says, I have this loan. So claimant and defendant compromise the original claim. Claimant effectively saves up this backup claim, keeps it in the wings, and then sends statutory demand in insolvency. And what the defendant does is applies to set it aside using this combination of Henderson and the insolvency rules to say there's a genuine dispute about this because if this were at trial, I'd have a Henderson strikeout defense. So interestingly, the court says that is available in principle. There's a big argument about whether it was available in principle at all. The claimant is saying the statutory demand is outside of court. It's a non-court kind of document, and so on. The court finds against the use of the Henderson argument on facts, and then on appeal, effectively, we come unstuck because the court says it's effectively an exercise of discretion, even though it isn't strictly speaking. It's very difficult to interfere with the value judgment that the judge below has come to on the point. But it's an interesting one because there's a settlement agreement in which the parties just don't give thought, and the claimant may potentially be quite deliberately hoping this will happen. The defendant is acting in person at this point, doesn't appreciate that this would happen. So it is actually a salutary lesson in how to make sure your settlement covers everything that you want it to, including anything arising out of the same facts. It's really an argument about release clauses in settlements. And this final case is a recent one, which is very similar in a discontinuance and compromise context. So I've just put the facts on there. The first claim is discontinued as part of compromise. The compromise, again, doesn't settle the underlying dispute. And it's a case where, on the facts, the second claim is found not to be an abusive process either. So that's about all we've got time for. I'm realizing we're running right up against the 45-minute time limit that we've set for this. So thank you very much for your patience. I've put my email address on the screen there if people have got questions, and I can see that there's a question already in the Q&A. So if anybody has got any questions, I'll spend a couple of minutes looking at them now. So just put them in the chat or the Q&A, and I'll have a look. They've got one from Sean Hackett. Hi, Sean. Where an assignee takes a statutory assignment of one of a number of causes of action from the assignor against the defendant, will the Henderson rule bite on the assignee if the assignor advances the other causes of action against the defendant? Let me just get my head around that. Yeah, that's a really interesting question. I think I probably have to do the counsel's answer of saying I need to look into that. I'm not aware of a case that specifically deals with it. There might well be one. Certainly the Marwaha case was an example of Henderson being used against an assignee unsuccessfully, but that was, I think, on the basis that the assignee had all of the causes of action vested in them the first time round. So it's not one where they're split in the first place. Yeah, we usually take an assignment subject to equities, so it would be an interesting one for a court. I'm not aware that there's a definitive answer. If I find one, I will drop you a line and let you know. But Richard Palmer, thank you for your question. Would initial disclosure obligations that have come in since the Barnett case affect the basis of that decision? Well, I suspect they would only have affected it in taking it further in the direction that it already went in. So I presume with initial disclosure, we're talking about initial disclosure in the business and property courts here. With initial disclosure, what you have to do is just give the other side copies of documents that are referred to in your statement of case or that are important for them to understand the case that you're advancing against them. Now, I think in that case, the bank is only relying first time round on financial instrument 1. It probably, if that's all that its claim is based on, it's only going to need to give initial disclosure about that instrument. So I suspect the answer is that financial instrument 2, even though the bank should have found it if they'd have exercised due diligence and they should have brought the two claims together, I suspect it doesn't technically amount to a breach of initial disclosure obligations because it's not pleaded, so it's not a matter for initial disclosure. But if the court were going to take it into account and say you haven't given the disclosure you should have done, then it's only going to reinforce the decision as originally made, I suspect, is the answer to that one. I'm not aware of any case so far on the interaction between Henderson and disclosure in the business and property courts, but it could be an interesting one if there is one. Right, that's 2 in the Q&A. Let's have a look at the chat. Hi, Leontia McArdle says, do you suggest that a compromise settlement should have a specific reference to insolvency proceedings, i.e. to bar the potential from bringing insolvency action and repurposing a dispute into a debt claim? I don't know if it would necessarily have needed to have a reference to insolvency proceedings, but I think you need to be, if you are entering into a compromise and you're worried that there's a potential for another claim against you, you'll want to have a properly drafted release clause. I think where the defendant in Mawaha came unstuck was that this was a sort of compromise negotiated piecemeal over a series of emails, if you look at the judgment. So there isn't a nicely drafted settlement agreement. I think if you were going to do a formal settlement agreement where you had a release clause, it would have something along the lines of, any claim or cause of action or dispute arising or said to arise from the same or substantially the same fact. So that's the kind of wording that you see. So I think that would probably cover proceedings, whether they are insolvency proceedings or straightforward debt proceedings, if you draft it right. And that's the sort of thing you'd want to look out for. I don't think the Moara decision was really so much about the distinction between insolvency proceedings and other kinds of proceedings. It was the factual matrix of it was that there wasn't a formal compromise and it just didn't set out what would happen next, and it effectively left a sort of open door for the claimant to walk through with whatever proceedings they wanted to. I think that is all the questions I've had. So thank you so much, everybody, for attending. Thank you for supporting our series. Hopefully see you at the next one, and good morning.